Hi, I am T. A. Srinivasan, General Counsel associated with various corporates and organizations. In my association with more than 3.5 decades, I have demonstrated that legal as a function can tremendously value add to the business and its operations. The support of legal functions in both top line and bottom line growth in an organization cannot be undermined. The topic discussed is confidential information and methods to protect it for the business, its owners, and the industry as a whole. Confidential information may take the form of number one, trade secrets. Examples: recipes in the hotel, software code in the software industry, formulations in R&D lab, etc. Business strategies and plans. Examples like M&A, brand acquisitions, hiring of details, etc. Financial data like revenue, expenses, geographical spread of trade, etc. Personal information like employee data, customer information, etc. And intellectual property matters like inventions, copyrights, trademarks are all confidential information. Research and development information like new product formulations, new product offerings, new research collaborations, and new initiatives, etc., forms part of R&D confidential informations. Schemes, incentives, below the line sales promotions, part of the sales information, confidential information. Customer database and relationships like customer list, customer spread, the demography will form part of that. Pricing and pricing strategies, new MRP, increase or decrease in prices could form the pricing information. Internal communications and memos like privileged communications, memorandum about operations to the internal customers forms part of confidential information. Confidential information are not protected by registration either under copyright or the patents or any other acts. If the acquired confidential information is published, used either personally or through others, without the owner's permission, will amount to breach of good faith, maybe breach of confidence, breach of trust, or breach of contract. Non-disclosure of confidential information is not necessarily dependent on any express or implied contract. This is based on the principles of equity. Breach of confidence. What is breach of confidence? The information must be confidential and should qualify for the same. It should be a confidential information. The information was shared in circumstances under an obligation of confidence. Unauthorized use of information to the owner's detriment, who was in possession of the confidential information. There is one doctrine known as Springboard Doctrine. The person who has obtained information in confidence is not allowed to use it as a springboard for activities detrimental to the person who gave the information. The possessor of confidential information is placed under special disability in the competition field to ensure it does not get an unfair start. Ingredients constituting the breach of confidence. What are those ingredients? The information in question should be traced to a particular source. 2, the information must be confidential. There was already an obligation, maybe not express or implied. There should be a usage of the information or about to use. There are laws and regulations governing protection of confidential information. In India, we have the Indian Contract Act 1872. Section 5 of the Contract Act talks about confidentiality. Information Technology Act 2000. Again, Section 72 of the Act talks about confidentiality. Information technology, reasonable security practices and procedures, and sensitive personal data or information rules, we call it as SPDA rules, comes under the confidential information. Right to Information Act 2005. In the Companies Act, Section 45 talks about inspection and investigation, comes under this information. Intellectual property laws, data protection laws like data protection regulations, industry specific regulations, for example, from the healthcare, etc., comes under confidential information. What are the protection measures? These protection measures are absolutely required. Number one is the non-disclosure agreements, get an NDAs. Confidentiality agreement or non-compete agreement, enter into non-compete agreements, encryption, have access control, passwords, biometrics, secure storage and disposal of records, limited access to authorized personnel only, background checks for employees, confidentiality training for employees, incidents response plans, have regular security audits in an organization to ensure that. To protect confidential information, certain proactive measures in an organization are required. Implement a robust security measures. Do not allow mobiles in the work floor. Restrict pen drives or other devices. Prevent access to private mails, etc. Conduct regular audit and risk assessments within the organization. Train employees on confidentiality. Use non-disclosure agreements to a great extent. Limit access to authorized personnel. Monitor and respond to incidents then and there, immediately. Continuously review and update policies, insurance compliance with laws and regulations, and make confidential information handled by senior employees with good track record and standing. Certain undertaking signed by an employee, the restriction contained thereon should be reasonable and normal. The restrictions should not be concluded as one relating to restraint of trade. This is very important. To this, we need to follow the guidelines laid by the Honorable Supreme Court in a famous case, Superintendence Company of India versus Krishnan Murugai, 1980, AR 1717. What are the consequences of breach for an organization? Financial loss. There will be tremendous reputation damage, legal action and civil criminal remedies, loss of competitive advantage, damage to the customer relationship may happen, regulatory penalties could be imposed, intellectual property theft could happen, business disruptions may happen. So remedies for breach of confidential information. What are the remedies available to me as a business owner? Cease and desist notice to be issued to the infringers of confidential information. Watch out if there is any development from the other side. Initiate proceedings immediately in the form of civil suit for restraint, criminal proceedings by filing complaint with the police authorities and cyber crime wing. An interlocutory injunction from the competent court may be obtained against the infringer, against misuse of the confidential information. If he continues using it, seek a permanent injunction from the competent court against the misuse of the confidential information by the infringer. Seek damages from the court by submitting the proof of damages and compensation. And compensation are decided based on the market value. Seek account of profits from the misuser and infringer who enriched himself by using the confidential information of an organization. There are various courts judgments, very interesting court judgments, like the Hindustan Unilever versus Reckitt Benichet, decided in the year 2014. Bholanath Mukherjee versus Union of India, 1974. Tata Consultancy Services versus Sintel India Private Limited 2005. American Express Bank Limited versus Priya P. Shaw 2006. The Data Protection Act in India is the Personal Data Protection Bill 2019, which aims to protect an individual's data and its processing. Some key aspects. The implementation status is still pending for parliamentary approval. The Personal Data Protection Bill 2018 is still in the offing. It defines personal data as any information that can identify an individual, regulates collections, storage and processing and disclosure of personal data, establishes data protection authority to oversee compliance, mandates consent for data processing, provides rights to individuals, data principles, right to information, right to corrections, right to erasure, right to portability, right to grievance redressal, etc. It imposes obligation on data fiduciaries, organization processing the data. It wants the transparency, accountability of data, minimization, security, data breach notification, etc. Some of the key provisions of the Personal Data Bill, which has not come into an act, however, it may come into act any time. Consent mandatory for processing personal data, data localization, data stored in India with exceptions, cross-border data transfer permitted with safeguards, data breach notification mandatory within, say, 72 hours, penalties 15 crores to 4% of the global turnover may be imposed. So, a confidential information in an organization plays a great role in the sense which should not go into the hands of a wrong person or a competitor who can put us into a problem. So necessary care has to be taken if these safeguards which have been discussed is put in place. Thank you so much.